welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here today with attorneys Nathan Seltzer and Clayton Calvin, and our Director of Litigation, Chance Weldon. We have been bringing you the Supreme Court cases more or less as they've dropped this session, but the October term for 2025 has sort of wound down. I guess there's some, we can't say it's come to an end. I'm informed that that is an inappropriate way to refer to this until October. So for now, we're just going to say that we have pretty much covered what we wanted to cover this particular season. So today will be our last episode for a while, and we'll talk more about what the future looks like toward the end of the podcast today. But we are covering one more case, which Chance has been absolutely champing at the bit to cover, and I think it's funny because it's a criminal law case, and I think I'm finally rubbing off on you. That's
no, I still hate criminal law cases.
That's what I'm going to say about this.
You have also been chomping at the bit, to be fair.
This is a great case.
Yeah.
I was more excited for it to come down before it came down, and I saw what was in it, and then I was like, come on, guys. Come on.
Well,
but we'll get there.
I think
we'll
the best explanation of that is when we're walking in today, she goes, "Oh, we're talking about a criminal law case. It's about, robberies." And I was
it's about bank robberies.
I was like, "No, it's not. It's a Fourth Amendment case."
Yep. This is an originalism case. This is a case about how the different justices on the court talk about originalism. Mm-hmm. Yeah, but it's also about bank robbers and appropriateness of warrants and how we do warrants, and there's some really fun law stuff here too. Anyway.
But it's not enough about how we do warrants. Right. It should be more about that.
Actually, yes. They gave us not enough guidance.
Yeah.
Again, we'll get there. So if you had not figured it out yet.
Is that an advisory opinion?
Oh, Nathan. We are talking about Chatrie versus United States. This is a bank robbery case. It stems from a bank robbery in 2019. A man with a firearm walks into a bank. Honestly, reading this opinion, it's like it's from a movie. I can't tell you guys enough how much this does not happen in real life, at least not this exact way. Guy with a gun walks in, hands the teller a note, says, I'm going to kill everybody here, or something along those lines.
If you don't give me... I've been watching you and your family, and I'm going to hurt your family.
Yeah.
Which sounds probably not true, but
normally
it's very scary.
That doesn't super work. Their banks have a lot of ways to prevent this from working, but it did this time, and the guy managed to make off with $195,000, which, if you were wondering, is not nearly enough money to get you out of the country and survive in a no extradition country for a long time. But he manages to get off with...
For all those potential bank robbers who are listening to our podcast.
According
steal
to
more money than that.
my criminal law professor, you need $12 million roughly to live out the rest of your days in a non-extradition country, and that's not a nice life either.
No, you're on the run.
Maybe he's old. Maybe he doesn't have much life left.
That's true. Maybe
is
he's
that
just
inflation adjusted?
Yeah. Is it inflation adjusted? No, that was back in 2019 that my law professor said that. Anyway, okay, so. The law enforcement, as they're doing this, have absolutely no leads at first. So they turn where a lot of law enforcement turns at this junction in an investigation. They go to Google. So there's two different types of location data that you can get from a tech company. And you can go to the provider, your telephone provider, and say, I want to know what cell towers this has bounced off of, so I can triangulate using the cell towers and say, here's the cell phones that were in the area based on the cell tower location data, which is called CSLI. The question of whether or not that's a search has already been answered in a case called Carpenter, and we'll come back to that. So instead of doing that, law enforcement in this case went to something called location history. So when you first power on a cell phone, a Google phone in particular, you'll get prompted to allow Google to use your location history to use your GPS, for example, to use... You want to get a coupon from Domino's, and it's your local Domino's. You're going to have to give them your location history. Right. Yeah. You want any sort of delivery, or you want an Uber, you have to turn on location history.
You get prompted a lot.
Those things. Oh, so many times.
I'm sure familiar.
Which is part of the opinion, actually, is how often they get prompted. So law enforcement goes to Google and
says...
By the
way, if you have an Apple phone, you're not safe. Apple also takes your location history. Yeah, if you have a cell phone... somebody's asking for and probably getting your location data.
And actually, it sounds like right now Google might be a little safer, but that's another matter entirely. So because they're not storing it in the cloud anymore, at least ostensibly they're storing it on the devices, so it's stored locally. But the location history is something that at this point in time was being stored in the cloud. So law enforcement goes to Google and says, hey, we want to know what devices what devices were in the area of this bank an hour before up to an hour after this robbery, which is really broad. This is just like a little aside. If I was the prosecutor reviewing this warrant before it went to the magistrate, I would have said, maybe let's narrow this down. You've got a picture of the guy on his phone. Let's say maybe 10 minutes before or after that picture was taken, so we can...
And you'd want to narrow it to make it more particularized.
Super narrow geographically.
More constitutionally
yes.
viable.
Yeah.
Okay.
Because those are all factors that a court will consider, at least in theory. We don't really know from this opinion. In theory, those are factors that a court will consider in deciding whether or not there's probable cause for this warrant. Mm-hmm. So anyway, they do get a warrant from a magistrate. It's called a 3-step warrant, which means they go to Google and say, here's the 2 hours we want on either side of this robbery. Give us all of the devices that are there but anonymized. So you know, Google, you still know whose devices these are, but we won't know. Mm-hmm. And then we'll look at those devices and say, hey, give us more information about these ones that sort of match our criteria. And then you'll send us that information, and based on that information, we'll say, give us information on this one particular person. And then they'll send non-anonymized information.
And this is all part of the original warrant.
All part of one warrant.
This is what they asked
about. It's a 3-step warrant. Step 2, the thing that's really important about step 2 is that you're getting more information about fewer people. So step 1 apparently produced 19 people. And of those, they said, okay, we just want this subset. I don't know how many people were in the subset 2, but they got more information, like where they went before and after the window. So now we're getting way more
data
info
about those people. Yeah. And then from there, that last request of, we want these 3 individuals fully non-anonymized. These are the names. These are the addresses. Here's everything we know about these 3 individuals. And then based on that, they did further police work, according to the opinion, just more stuff, decided it was probably Mr. Chatrie, and then they brought a case against Mr. Chatrie, and he was convicted, and it went before the, I suppose on a habeas, it's not real clear to me from the opinion itself, ended up in front of the Court of Appeals for the 4th Circuit. And 4th Circuit said it wasn't a search in the first place, so no warrant was necessary. And importantly, for things we're going to discuss later, they also said even if it was a search, the good faith exception would have applied here. Mm-hmm. Even if this was a defective warrant, it was a search, this was a defective warrant in some way, the good faith exception would cover these law enforcement officers.
What's the good faith?
Yeah.
What's the good faith exception?
The good faith
prosecutor?
exception is when, and see, this is the last resort of a luckless prosecutor. Good faith exception is when law enforcement does something believing that they're doing it right, particularly seeking a warrant, believing that their warrant has sufficient information, it's signed by a magistrate, and then later a court looks at it and says, yeah, the magistrate should not have signed that. Yeah. Because the magistrate signed it, we say the officers acted in good faith on that warrant, and that information is not excluded under the exclusionary rule. Chance, you want to tell us what the exclusionary rule is?
The exclusionary rule just means that when you get something in violation of the Constitution, evidence, documents, whatever, you can't use that in the prosecution if they were obtained illegally.
But the Constitution itself does not provide for the exclusionary rule. The court created it in order to disincentivize police officers from violating the Fourth Amendment. And the rationale here for the good faith exception is that if they were acting in good faith, then this disincentive wouldn't operate on them anyway to prevent them from doing it, because they would have done it anyway because they didn't know that it was violating the Fourth Amendment. So there's no reason to attach the exclusionary rule if they're acting in good faith.
Exactly, at least in theory. Mm-hmm. And this kind of comes down to the fact that we have applied sovereign immunity to cops, and once again, the issue is always qualified immunity. We would have a different set of circumstances and a different disincentive structure if these people who had their constitutional rights violated could turn around and sue the officer who violated their rights.
Yeah,
kind of similar, except for that qualified immunity is a violation of a statutory.
Yeah.
Well, I mean, it's two things. It's right. It's like, Justice Thomas and others have historically said the exclusionary rule is made up. It's a judge-created doctrine. It's made in equity to sort of disincentivize bad behavior, which is correct. Mm-hmm. The problem is that it was made up because they had also created a doctrine of immunity that said you couldn't sue these folks for tort. Because, at the common law, or back in the 1790s, if someone, say, for example, kicked in your door without a warrant or without a valid warrant to search your home, you could sue them, that individual officer, in their individual capacity for trespass under state law. And you could get damages for that unlawful search. You can't really do that anymore because of immunity doctrines. And so without that, there was no real disincentive to prevent police officers from just, I don't know, searching your stuff.
Yeah. To just jump in and do the thing, because why wouldn't they?
Yeah.
They just want to put bad guys in jail, so we're just going to let them. So the Fourth Circuit has this basically 3 different reasons for affirming this conviction. The first is it's not a search in the first place. They don't super pass on the warrant thing. It sounds like the question of whether or not the warrant was valid is hinted at, that yes, it was probably a valid warrant, but even if it wasn't, the good faith exception would apply. So we've got this kind of 3-tiered opinion coming out of the Fourth Circuit. A problem arises in the way that the Supreme Court decided to grant cert on this. They only granted cert, or at least they only passed on in this opinion, the first question of, is this a search? They did grant cert, I think, on the first and second, is this an appropriate warrant? But at the end of the day, the only question they answered is this a search? And the answer to that is yes. And go back to the Fourth Circuit to decide all of the other information. So this is
Which the Fourth Circuit arguably already decided. So
yeah, it's unclear how much this helps the remand process.
Yeah.
Not very much.
I know law enforcement was really watching this one, waiting for this one to come down, because the question of how much information is necessary for these warrants and can a 3-step warrant like this ever be constitutional is a big, important question. Because this is how, at least up to this point, Google was doing all of their warrants. This was their warrant requirement.
Yeah.
And so we're talking hundreds of thousands probably of these requests are going out to Google and others. We need to know if those are constitutional or not. And that question wasn't answered. So
yeah, they said 9,000 were issued in 2019. So it's probably increased
in 1
since
year.
Then. Yeah, that's not requested.
9,000
issued.
were issued.
But the answer to the question that they did answer, the fact that it is a search, was really important. Because the argument that the government was making is you don't have to figure out reasonableness or scope or particularity or anything else because it's not even a search.
And the reason the government said it was not a search is perplexing to me. Their frontline argument was it's not a search because it's very short in duration. It's just 2 hours. Yeah. Like, okay, it's not a search.
I was only in their
all I did
house
was
for
reach
an hour.
into one of your pockets. That's not a search. Like, how is that your argument? But it's because the other one was really foreclosed by Carpenter, which is it's not a search because of the third-party exception. Clayton, do you know enough about the third-party exception to tell us what that means?
Yeah, basically. I mean, I think the third-party exception is basically to say that it's not a Fourth Amendment violation if there's a intermediary in the process, like a private party, like a cell phone company or somebody who is giving your information to the government instead of the government doing it directly. So
the 2 cases that kind of decided this, or kind of mapped the outlines of this, is all we have on it really. Is one is that the number that you actually physically, we used to have to do this, you dial your number physically into a phone, and whether or not you were providing that information to the phone company. And they said, yeah, that's pretty much like saying, operator, give me 7219 Delta or whatever.
Public or whatever.
Or
it's to another party.
It stems from a really obvious point of law, which is that if you tell something to another person and the government asks that person for that information, they can give it to the government. So like if I tell you, Clayton, hey, I murdered somebody, and then the government comes to you and says, hey, Clayton, did Laura Beth tell you she murdered somebody? And your answer to that is yes. That's not protected by the Fourth Amendment.
I would never do that to you, by the way.
Well, it actually comes from a weirder place. The history of the third-party doctrine, and Gorsuch talks about this later in his separate concurrence.
Government action.
Well, so the Fourth Amendment protects you against unreasonable searches and seizures of your person, houses, papers, and effects. And so the question is like, what constitutes a search? And historically, this was physical trespass. Like basically, if you were a trespass at the common law to your personal, your person, home, effects, that would be a search. But as you get into the 20th century, when they were dealing with wiretaps and other things where they weren't physically entering the home, you have a case called Katz, K-A-T-Z.
Or Katz, if you aren't from Houston.
You like musicals.
Yeah.
And you like musicals.
Right? Yeah. And so Katz, it has a K. So Katz, what they said is what actually is going to trigger a search is whether or not the government has invaded a reasonable expectation of privacy, right?
And which court decided Katz?
The United States Supreme Court.
Well, but specifically, that was the Warren Court, right?
Burger?
Was it Burger?
What year is Katz?
I want to say it was
70s, I think.
60. I want to say it was 65, but I'm not certain.
Right.
Probably that's Warren Court, right?
Sure.
I might need a timeline, right? And so
It's right at the end of
I
it,
thought
either
you
way.
would
They're
know.
not that different
often.
anyway.
No.
My assumption, Chance, is that you always know things.
which is why you asked me questions about cases we haven't prepped. No, but so Katz.
1967, by the way.
67. So
Justice
Katz,
I was
Black.
not that far
I don't
off.
have the
Black dissenting,
laptop,
yeah.
right? So Katz says instead of these common law ideas about trespass to persons, houses, papers, effects, is it an area that's entitled to a reasonable expectation of privacy? And the third-party doctrine sort of springs out of this. It comes out of this idea that you don't have a reasonable expectation of privacy for things that you've shared with a third party.
I mean, that's exactly what I was saying, that I don't have any reason to expect that once I give that information to Clayton that he's going to keep that information secure. I don't have any basis for that expectation because he can always be called as a witness.
But that's because something I say is not a thing to be searched. But if I had given...
Under an appropriate understanding of the Fourth Amendment, yes, you're correct.
But
yes.
if as Gorsuch points out later in his concurring opinion, if I had given Clayton like my keys to park the car or something, like when we were going out to eat, and that wouldn't mean that now while the car's parked, the police can search it without a warrant because I don't have an expectation as to Clayton to what was in the driver's side seat.
Nor could they say, Clayton, give us the keys because those aren't your keys, so we just get them now. Yeah.
Right.
Right.
Because
if you actually do have a property interest, and if it's more than just information about you.
I feel like we're jumping way ahead, though.
Yeah.
But
yeah,
yes.
a little bit. Okay,
sorry.
so let's
my fault.
Rewind a little bit. The court's opinion in this is both fairly short and fairly straightforward. They essentially say, look back at Carpenter, which dealt with all of these same questions. And Carpenter's holding is that the third-party exception does not apply to CSLI, to cell site location information. Because, and this gets a little bit weird, because it's not truly shared with the third party. In other words, they say this is not information that you're voluntarily handing over. It's just sort of incidental information that occurs as a result of an action that you're taking. So you're not really sharing it.
Think of it like a safe deposit box at a bank.
Now, like you said, Nathan, the big cases dealing with the third-party exception are telephone and bank cases. So the question of what contents are, or what information is in your bank account, you're sharing with your bank because your bank is kind of helping you with it, I suppose, is the logic there. Yeah. And when you're dialing that number, you're essentially talking to the operator, right? Yeah,
like if you write a check, like the numbers on the check are circulating among different banks and stuff, and so you shouldn't expect that your account number is private when you're writing checks, basically.
Yeah. But if you frame it the right way and say your cell site location data, or more specifically, actually your location history, I am going to talk to the operator of Google and say, please tell me where I am using your GPS. I don't see functionally how that's any different, which is something that Justice Gorsuch points out in his concurrence as well. Functionally, that seems to me at least to fit the same mold. But the majority in Carpenter and the majority here said, you're not really sharing it. This is just sort of a incidental information kind of situation.
And they're using the reasonable expectation of privacy framework to begin with. That's
they lean in with Katz.
Yes.
Yeah. That's why this whole, they lean in with the musical. They start singing it.
They start snapping.
Right. That's
West Side
that's
Story.
I don't know.
Okay. All right.
Know your musical. Come on. You expect to be on a legal podcast without any knowledge of musicals? Anyway, the whole reason that this kind of works is because they're using the Katz framework, which is not necessarily how you have to do it.
But the polite fiction that we're all maintaining here, maybe it's true even, is that the data that Google is storing, they're storing it for you. They're storing your data. It's you can delete it anytime off of their servers, and no one else can access it except with your password and your login credentials. So it's I think the best analogy here, the one that I heard, was that it's like a safe deposit box at a bank. Like the bank is storing your stuff, but it's still your stuff. The government can't go to the bank and be like, hey, open all these safe deposit boxes because, you're in control of it. They have to get a separate warrant
your
for that.
thing. Yes. Yeah. So like I said, it's not really that complicated. I don't even know that we need to say more about the majority opinion.
Yeah, it's a little more mushy. I mean, it's written by Elena Kagan, so even some of the examples we're giving have more of a Gorsuch flavor than what the majority does.
That's us.
That's us. The majority opinion is very much within the Katz framework, that like a person would have a reasonable expectation that because everyone uses phones, it's ubiquitous. Data tracking is
it just goes into like how personal and sensitive and widespread phones are.
And you're prompted a million times to share this information with Google.
And that's a good point. I think that was an effective point that she made, is that you're not really consenting. I mean, you're kind of consenting, but not in any meaningful way, because you're just like
it's not
hounded
the same as
by it, and your phone's not going to work
if
you don't consent to it. So she's just like, that's BS. You have a reasonable expectation of privacy.
If I just take a moment to imagine the alternative scenario where it's okay for the government to get this information
without any sort of warrant.
Like we live in an age like virtually every app that you use requires a consent form that's like 10 pages before you can ever use the app at all, and virtually no one reads it. Maybe the attorneys in this room read every consent form. Maybe.
I don't.
But many times you can't use the app unless you agree, right? And your United States government argued that click to use that app makes all the data that you give to that app, whether it's Flappy Bird or Google location history or Crossy Roads.
Flappy Bird. I haven't thought about that in a long time.
Whatever it is, Crossy Roads is the new one.
All of these things
I used to feel safe playing Flappy Bird.
That your United States government argued that click lets the government access all your data from the app, whatever it is. And if the government had won,
they would know my high score on Flappy Bird?
But
China knows your high score on Flappy Bird.
If Crossy Roads has your location, then they would also get that. If Crossy Roads has your credit card information, like all the things that you put in there, government gets. And that's like game over. The Fourth Amendment becomes an ink blot for anything that you have in the cloud.
Oh, it's more aggressive than that. I mean, by their rationale, the third-party doctrine, just because you've shared it with Google, they didn't have a good answer at oral argument for why that wouldn't apply to the contents of all of your email.
Yeah.
Right? And not just like that they could get it, but that it's not even a search, which means the Fourth Amendment doesn't even apply at all.
You don't even have to ask for a warrant.
Yeah.
Right.
The question isn't like, is this an unreasonable search? It's like, is it a search?
Yeah. Because ultimately, if you view the third-party exception with any degree of logic, you're going to reach a place where it swallows the entire Fourth Amendment. The third-party exception becomes
at least in the digital
Fourth
space,
Amendment.
right?
At least in the digital space, yeah.
And something like, even if you delete the app, the location tracking like services that you consented to trying to use that app like remain on your phone.
Right.
Yeah.
Right.
Mm-hmm.
I can't go into any great detail on this because I think the investigation is still pending, but I did have an officer at one point come and tell me that he had been able to track down a perpetrator for, unfortunately, a child sex crime, but the man had been incredibly meticulous about denying location history for every single thing on his device, except for his Taco Bell app. He wanted his Taco Bell coupons, and so that flagged his location history, and that meant that we were able to see his location at this particular child's house at the time of the offense. So so
good outcome in that case.
If you want tacos,
probably a Fourth Amendment.
Maybe ask at the window what their coupons are.
Do it the old-fashioned way.
Hopefully, so let's look at the Taco Bell app. So hopefully,
or don't commit sex crimes.
Yeah.
That's your other option.
Go get tacos.
Don't do that.
But if hopefully the police officer suspected that this guy committed the crime, and they're trying to, and they've got a warrant for this guy's phone and data.
Right.
Yes.
That's okay.
Validating him.
The warrant was particularized as the Fourth Amendment.
Yes. Yeah, which is
what Jackson talks about.
Exactly. And actually, that's a great segue. Thank you, Clayton. Let me move us on to some of these concurrences. Justice Jackson sort of answers, at least a little bit, the question that my law enforcement officers wanted to know the answer to, which is this three-step warrant unconstitutional? She says, in our opinion, this is speaking for her and Justice Sotomayor, yes, this three-step process is unconstitutional because with respect to that second step and the third step, you don't have a magistrate signing off on those things, even though they might be particularized. And that's an important point with respect to this warrant. The warrant,
they're particularized as to the officer's because of the officer's discretion.
Yes,
but they're not particularized in a way that a neutral arbiter like particularized them.
Yes, and signs off on it.
Yeah.
So the although the warrant instructed the officers to particularize for steps 2 and 3, there was nothing holding them accountable for that.
Tell them how to. Yeah.
Whereas if you had to go back to the magistrate and say, okay, here's the 19 that they gave us, here's the 3 or 6 or whatever.
And here's why we think that these people need more scrutiny.
These ones meet our criteria. They fit these other qualifications that we need. You know, they were exactly where we needed them to be at the right time, et cetera, et cetera. And then now can we have more information on these? And then go back a third time and say, these are the ones that we need non-anonymized, and here are the reasons why, and ask the magistrate at that third step.
So Jackson providing some very practical guidance.
Very practical guidance. It's again a very short little concurrence, just saying we are pretty sure this is how we would hold on this, which is totally fine in the context of a concurrence.
Right.
And that brings us to what we've all been chomping at the bit to talk about, which is Justice Gorsuch. Chance, would you like to talk about Justice Gorsuch?
So,
is the Pope Catholic?
Yeah, is
the Pope Catholic?
So Justice Gorsuch agrees with the court, but not with the court's reasons at all.
He agrees with the outcome.
So he only concurred in the judgment, which is different from other concurrences.
I just realized that you've just added to the confusion of the Nathan Chance confusion, because people say that our voices sound. People say that our voices on the podcast sound alike, and then Laura Beth was like, "Chance, can you do this?" And then Nathan's like, "Yes, I can."
I will answer.
You're slow. I'm litigation
You're just
director.
becoming
Nathan.
each other.
No, so so Gorsuch this is a very Gorsuch opinion, where he's basically like, you guys are doing all of this wrong. Y'all aren't being originalists at all. And he makes the point that we were making earlier, that this whole Katz thing is completely made up. The reasonable expectation of privacy thing is completely made up. What we should be doing in Fourth Amendment cases is saying, is this property? Is it a paper or effect or a home? Or is it analogous to that, right? He says, just like, for example, we think about the freedom of the press was printing presses in the 1790s, and now it's internet web pages.
But press is a broader word. Arms is a bigger word than just muskets.
Yeah, it's not just muskets. We just apply by analogy what it would be today. And he says, if you do that here, don't overcomplicate it, guys.
Yeah.
Just apply the modern technology and say, like, would this be something that would be a paper or effect at the time of the founding? He says, yeah, this would be like if I had a diary that I was storing somewhere, or if I had, these are the sort, and just the fact that I store it in a third-party location doesn't mean that it's no longer my property or effect,
Yeah, it's your effect. And importantly, too, because this kind of tripped me up a little bit, because I was thinking, it's a little bit strange to consider that you have a property interest in just information about you, like where you were located. But as you pointed out earlier, which I think it makes much more sense in the context of the terms papers and effects, it's the recording of your location.
Right.
Like the recording like you would in your diary or whatever. You do have, that's yours.
And Google goes out of its way to identify that for you as something that belongs to you.
Yeah.
You have complete control over that information. You can give consent to access
over
it. You
the
can
records
withdraw.
Of that information.
Right.
Yeah.
The records of that you can withdraw consent. You can ask them to fully delete it from their servers. You can ask them to, limit who has access to it. You have complete control over this because you have a property interest in it.
Right. And if we think about how we define property interest as a bundle of sticks in law, and we just kind of walk through that, you have like the right to exclude, the right to alienate, the right to, to sell or transfer or destroy. And you have all of that under the Google contract, is Gorsuch's point. And so in any meaningful way that we talk about property in the digital age, at least for Fourth Amendment purposes, this would be clearly property. And then he does some, he takes some broadsides at the reasonable expectation of privacy test, both the third-party doctrine, both as a matter of doctrine, but as a matter of practice as well. And he says, like, look, and we were talking about a little bit of this earlier, just because I would say, like, let you borrow my car or let you do something, like give you a bailment of some sort of my property, doesn't mean that I've waived all of my Fourth Amendment interest in that property forever.
Right.
And again, these are things that just like make sense if you don't overcomplicate the doctrine.
You're just giving Google custody of your property.
Yeah.
And bailment's like when someone else is holding on to something for you and then they're going to give it back to you later. Like they don't get ownership of that thing.
Yeah. And I can allow you to have access to my property for certain purposes. And that also doesn't waive all of my Fourth Amendment interest. If I let you stay the night, because you're in town or something, I let you stay the night on the couch, that doesn't mean that I now lose all Fourth Amendment interest as to the police in my living room. right? Because there's a third party that's had access to it.
Or even to the couch.
Yeah, or even to the couch.
He has a great line, just a great kind of discussion about why the Katz test makes no sense. He says, "Count me unpersuaded. Why does tracking Mr. Chatrie's movements digitally over an hour or two invade his reasonable expectation of privacy when an officer tailing him for the same length of time would not?" See United States v. Knotts. Why is location data history Mr. Chatrie voluntarily shared with Google not truly shared when a person's bank records are? See Miller. Does the court mean just to give Katz's third-party doctrine a quiet burial by suggesting today that any information shared over quote-unquote smartphones using apps and services falls outside its reach? And what does any of this have to do with the Fourth Amendment's terms anyway?
It's all haphazard and it's all very subjective.
It's all haphazard.
It's all vibes.
It's all vibes.
Yeah, it's definitely vibes. Correct me if I'm wrong, but the original Katz, I'm going to start using the original German as Chance does. That's because he's a scholar. The original
I think it's just because you don't want to think about the musical every time you say the name.
That's a big part of it too. Okay.
Please do, Nathan.
Lots of debate among CAF. But the test, I believe, it's something like the person had an actual and subjective expectation of privacy. And secondly, that is recognized by society
as reasonable.
So there's a subjective and an objective component, which I think is wild to say that a constitutional standard depends on how the person was thinking or feeling while they were in the phone booth or whatever.
Yeah, and it's something
that
also moves over time with the way that society thinks about things.
Yeah.
Like as technology changes, you would have the Fourth Amendment ebb and flow with like what's available because of technology.
The point of signing a social contract.
Yeah, I mean this came up with the Kylo case. This was where they were doing the thermal imaging, and the police were just strolling down the road and doing thermal imaging, like looking through the walls of people's houses,
specifically looking for marijuana, I think, for grow lamps.
Yeah. But as Justice Scalia pointed out in his majority opinion in that case, it would allow you to tell like whether or not the lady of the house was in the bath as well. Like this was pretty invasive stuff.
Yeah.
And they were arguing it's not a search because hey, look, we didn't everyone knows that this sort of thermal imaging technology has been available for years, so you don't have any reasonable expectation that someone wouldn't be looking through your walals. And
you gotta expect that your neighbor is definitely looking with thermal imaging at your house.
And Scalia rightly said, no, this is something that but for the technology you would have to invade the home for. So it's certainly a search. You're like looking through the walls into the interior of a home. And if you ask somebody in 1790 if that was a trespass or a search, they would say certainly it is.
And that's a conclusion get to directly from the text without this whole subjective.
Without this whole
society's different now.
But what I do find fascinating about Gorsuch's takedown of Katz, where he says like, well, why would you have a reasonable expectation of privacy in the data whenever you wouldn't have a reasonable expectation that someone could just follow you around? That's usually the argument that people make to get around something being a search for Fourth Amendment purposes. That's usually a very pro-law enforcement kind of argument. That
of course I can follow you around. That's not a search.
Yeah, you don't have a reasonable expectation of privacy. But Gorsuch goes like the full step further and he says, but that's because the reasonable expectation of privacy test is stupid.
Yeah. Because this is dumb.
Yeah, and what's like bad for the goose is bad for the game. If you have like a subjective, mushy test, even if we're using it right now to like protect privacy, that kind of analysis lends itself to abuse by the government, actually.
Yeah.
And this does have just the absolute masterclass that Justice Gorsuch does here in how originalism works. He says, what's the text of the Fourth Amendment? Okay, does this count as papers and effects? Okay, yes, it counts as papers and effects. So is it a search? All right, let's look at the dictionary from more or less the era. He quotes 1828. It's a little after the fact, but pretty close, saying the government conducts a search
to critique about that
when it looks over or through for the purpose of finding something.
Yeah.
That's the definition. So if you are looking through the data, which we've already established, the data is an effect, it's personal property. Yeah. If you are looking over it or through it, you are conducting a search. And there you go. Ding, ding, ding. And that's how the Fourth Amendment is applied.
Mm-hmm. I just want to go through life with the level of confidence that Justice Gorsuch has in his concurrences. Where it's like, here's this thing that all of these scholars on the court are arguing about. There's been 100 law review articles. There's 50 amicus briefs. And Gorsuch always shows up and he's like, this is easy, guys. Like, why are we making this so complicated?
And writes by himself, too. Like, he's just like, you guys are all wrong. 8 people wrong, me right.
Not just that you're wrong, but like, this is simple. Here's a dictionary.
He definitely provides a really coherent, simple view of how the law should be, and it tracks with itself across different bodies of law, which is like a good signal that that's an effective and probably accurate way of looking at it. Like, for example, like he's not saying necessarily here, I don't think he said that this is a search is rooted in like a common law trespass necessarily, but it's very adjacent to that.
Yeah.
Like, we're looking at the text, but like the text, papers and effects, comes out of like common law ideas of personal of trespass and like Lockean ideas of property and stuff. So it all makes sense with itself.
So all of that beautiful opinion aside, he doesn't address something that's brought up by the dissent in this case, and neither does the majority opinion, which is the issue of this might be an advisory opinion. First off, who wants to tell our listeners what an advisory opinion is? Actually, Nathan, this is your problem now, because you have strong feelings about it. This is your problem, because I know what position you take on this.
Yeah, so I think that there's actually disagreement at this table even on what constitutes an advisory opinion.
We shouldn't have asked Nathan.
Yeah.
So
tell us the wrong definition of an advisory opinion.
Okay, so I'm going to ask Nathan, and then Chance can chime in. Nathan has the talking stick.
So an advisory opinion we typically think of as when the court does not have Article 3 jurisdiction over a case, there's no live case or controversy, and the court is just saying, this is what we think the law is or the law should be. That's an advisory opinion because it doesn't affect the outcome of the case. It doesn't affect the litigants in the case in any way. So we're looking at things like standing, ripeness, mootness for whether or not something's an advisory opinion. I think we generally agree on that.
Yeah, I think that's right.
So that being said,
in addition to that,
I think that this might be an advisory opinion. I think maybe we all agree on that part, but I think it might be okay. But first, Chance, tell me why I'm wrong. Why it's not okay.
Well, no, I think we should start with where we agree that it is, in fact, an advisory opinion. That
at least there's a strong chance that it's an advisory opinion.
It feels like an advisory.
It feels pretty advisory.
Alita's making some points.
Go ahead, Chance. I'll let you. shape.
I'm happy for anyone to explain why it doesn't provide any relief to the parties in the case.
Well, so part of the question presented did not include whether or not the good faith exception applied. Like, the court accepted that the Fourth Circuit had accepted that even if this was a search, that the good faith exception applied, and therefore this evidence would come in, and therefore Chatrie would be convicted.
I disagree with that.
So there's nothing that I'm talking now.
I'm sorry.
Now Clayton has the talking stick.
Okay.
So there's nothing that the court can do to actually change the outcome in this case. Maybe it can render advice to future cases, which is what advisory opinions do. Mm-hmm. But there's nothing that could actually change the outcome of this logically. So it was like doomed from the start as an advisory opinion, because it's not going to change the outcome for Mr. Chatrie.
Because even if it is a search, they didn't challenge the fact that it wouldn't have been excluded. And so he's still convicted. There's no change. He's still sitting in jail.
It's admissible no matter what. That's the real world hook. That's the the factual injury that gives you standing. And so if nothing changes about that, then there's no reason for the court to use its resources to like make these declarations about what is a search, how do we get to that conclusion, all of this, because there's no underlying factual controversy anymore.
Yeah.
So I'm going to disagree. And I think, and I'm going to do it like in the knowing that I'm the least intelligent attorney at the table, and I'm still going to articulate that I disagree.
Another thing we agree. I'm just kidding. I don't agree with that at all.
Chatrie had standing, Article 3 standing, clearly, I think everyone would agree, when he challenged his conviction under the exclusionary rule. And he said that the Fourth Amendment protected his right, which is a question that is before the Supreme Court right now. The Fourth Circuit decided, it is a very complicated decision at the Fourth Circuit, but they split on whether or not it was a search for the purposes of the Fourth Amendment, and that is the question that the court passed on here. But what the court decided, the Fourth Circuit decided below, though, and with a majority of judges, 9 judges, was that the good faith exception applied even if it was a search. So the question is, does the method of reasoning and the court's decision on what question to take, could that deprive the Supreme Court of jurisdiction over the case? And I don't think it can. I think that the Supreme Court can revisit the Fourth Circuit's reasoning in the case so long as the litigant had standing. In other words, it was a justiciable controversy when he filed his habeas corpus, whatever method he had of challenging his conviction. So otherwise, we could see ways where the court could tailor its reasoning in a way that the Supreme Court would not be able to review what the Fourth Circuit in this case did. And the Supreme Court, in taking the case, is saying, Fourth Circuit, you did the reasoning wrong. We're coming to the same outcome that you did, maybe, or maybe it doesn't change the outcome for the litigant, but your reasoning was wrong, and we got to correct that here. That's my take on. But I think it's still an advisory opinion because he still loses, right? Like it's going to go back.
That makes a great. Those are all great points. But they should have also then taken the question of whether the good faith exception applied, because that's the thing that makes it.
I don't think that they have to take that question in order for it to still be a live case or controversy. In other words, like, what if the Supreme Court granted cert and said, we just affirm. We grant cert and we affirm, goes back. Like, they haven't actually changed the outcome for any of the litigants, but they still passed on the actual live issue. In this case, the real problem that you would say it's an advisory opinion is the limited grant of cert. That they said, we're going to grant only on this question that doesn't actually determine the outcome of the case. And the question is whether or not the Supreme Court is prevented from granting cert in that circumstance by the Constitution.
Yeah. And you're saying it's still a case or controversy,
yeah,
so it's still okay.
Well, in order to be a case or controversy, like the scope of the controversy is the issue presented that's granted cert on. That is now the case before the court.
And what you're saying is
that must have an element of controversy in it, or you don't have jurisdiction over that question.
But Nathan is reading it more broadly, saying the entire case just has to have a controversy,
right?
And you can pick.
But the entire case is not before the Supreme Court. And so the question of whether or not you have to have redressability at every stage in order to have a case or controversy at common law under Article 3, like, you would have to be the relief there has to be some ability for the court to grant relief on the controversy before it, and the only controversy before the court is whether this is a search.
And if answer yes, it's a search, then the good faith exception applies, and if answer no, it's a search, then the litigant still loses.
Yes, so there's no redressability, period. And at that point, it is an advisory opinion. There was no jurisdiction when it granted cert from the very beginning, because the controversy between the parties, which is defined by the question presented, can't provide any relief. And so it's not a case or controversy in the standard sense that we think about jurisdiction.
So what is the defect then? Is it that the Supreme Court couldn't have granted that question, like, granted cert on just that question? Like, that's the thing that's forbidden here, or the way that they
I think that's it. Unless they were going to put up there the possibility that the good faith exception does not apply, then they're just going back and fixing the reasoning of lower courts, which is not what the Supreme Court does.
That is how you were describing, right?
I think they are fixing the reasoning.
But isn't that sort of advisory?
Can I ask kind of a technical question?
Yeah.
So can the Supreme Court, I think I have seen them do this, create and craft their own question presented for a grant of cert?
Yeah, they've done that.
So they can reach out and say, here's the issue that we want to decide.
Yeah.
So because they can do that, I think that one of Nathan's predicates has to be wrong in his logical analysis, which is that the court can't lose jurisdiction once we've satisfied that Article 3. Because if, for example, the question that came before the court is like, let's just say WOTUS. Does WOTUS apply in this circumstance?
Yeah.
Yes or no? That's the question that was presented, and the court reaches out and says, okay, we instead want to decide whether or not this is water that you guys are talking about.
Yeah.
If that's not in controversy, we both agree it's water, it's just, does WOTUS apply, yes or no? If the court was to reach out and grab that question, even if the parties still had standing and still had Article 3 jurisdiction over that, does WOTUS apply, yes or no, the court has lost jurisdiction by grabbing that specific issue that doesn't have an effect on the outcome and that neither party has raised.
I want to distinguish that.
Well, I would say two things. One, you have a party presentation problem, and we're not going to have that. We're not going to have that fight. But assuming, so let's just assume that somebody in the case had argued about water, right? Mm-hmm. I think the question would have to be: is this a question that would actually move the needle one way or the other for the parties? It doesn't have to, again, because the court takes questions, not cases. But still, the controversy, the question presented, has to actually have some downstream consequence for the parties. Otherwise, there's no redressability.
So I think that the difference between like the question of like water, whether or not we're going to talk about what water is and whether or not it's at issue in the case, I think it's like we're talking about a fact or something like that versus legal reasoning that came later. Certainly, there could be changes in the facts of the case that could lead the court to lose jurisdiction. Yeah. But can a lower court's reasoning deprive the Supreme Court of appellate jurisdiction on a question that it wants to answer about the case, which is at the district court level was a live controversy about whether or not it's a search. And I don't think that the district court's reasoning or the Fourth Circuit's reasoning could prevent the Supreme Court from reaching and grabbing an issue that was a live issue when it was brought. That's sort of the distinction, even though I admit it's advisory.
So I think, going back to John Jay, we don't get to have advisory opinions within the jurisdiction of the court. But I think that the difference there is that you're looking at if the issue doesn't move the needle one way or the other, then you're basically just a roving band of grammar. Like, could they pull something up to fix the grammar in the appellate court's opinion?
I think they could.
No, they couldn't, because it has to actually move the needle in the outcome. Otherwise,
I think prudentially, they shouldn't.
Prudential standing's made up, but like
okay. But I mean, prudentially, they don't have to grant cert on that. Is what I mean. Like they don't have to do
but they can't, because it doesn't actually move. It doesn't resolve a controversy for the parties. Because remember, appellate jurisdiction is of the judgment,
right?
Not the like opinions are helpful to the lower courts, but like what the court issues are judgments under Article 3.
Agreed.
And so they can go back and change the judgment, and they have jurisdiction to change a judgment.
But they can also affirm the judgment.
Yes, because in that case, one side, if it were reversed, it would change the outcome of the parties, right? Yeah. Only if affirming or denial would actually affect the outcome.
Yeah, I agree with that. So I think we'll just leave it there. Yeah. I think there's a fundamental.
This is probably as good a place as any.
The constitutional text, I was just like looking for it as y'all were talking. The judicial power shall extend to all cases arising under the laws of the United States and of the Constitution. Yeah. So like the text that we're analyzing is case, which is a little bit broader than like controversy potentially. But
I mean, it would still require you to have standing, like a case which would require injury, traceability, redressability.
Well, yeah, that's true.
Redressability is the thing that the problem that you have here is at each stage.
But all the standing comes out of the term case. Is all I'm saying.
Yeah.
So it's not necessarily error to read it a little more broadly, but
I just think that the Supreme Court should always be free to correct an appellate court's legal reasoning, and that the appellate court can't craft its legal reasoning in such a way that something that it says becomes unreviewable by the United States Supreme Court.
I mean, it wasn't unreviewable. The Supreme Court could have just opined on the other two issues and said, actually, here's why you're wrong about these.
But if it doesn't want to.
But just because it doesn't want to doesn't mean it doesn't have to.
But if you can decide the case, but doing it a different way.
I'll just say this. I'll end on this. All 9 justices agree with me that there is Article 3 standing in this case. Even the dissenting judges who say it's an advisory opinion, they admit that there's Article 3 standing.
Alito mostly said it was improvidently granted.
Right.
Yes.
Which is slightly different.
And also believes that the third-party doctrine is alive and well, and goes to great lengths about that. But I need to wrap us up now. We are out of time for today. So before we end, first of all, Nathan, give us the scorecard.
6-3. The government's geofence warrant was a search under the Fourth Amendment.
6-3, including that one concurring in the judgment by Justice Gorsuch. Right. But we do still have a binding majority opinion, which still leaves Katz alive and well and kicking, and that's still the standard in the United States. So, okay. Real quick, before we wrap, I just want to explain for our listeners, and possibly for you guys, I don't know to what extent I've communicated this to you. This is our last podcast for this session. We'll have some intermittent podcasts as the winter rolls on. Eventually, I'll go on maternity leave, and then it's up to you 3 to decide what you want to do. We'll have I think we're going to have some judges join us for some interviews. We'll do some fun things.
Congratulations.
Oh, thank you.
Oh, yeah.
Yay.
So
we all knew that already. So
I
don't know if it's official. So.
You've all congratulated me offline. So we will wrap this season today. Some intermittent podcasts here and there between now and next April, but we'll pick up again with our October 2026 session starting in April of 2027. So you guys can hear our mostly originalist takes on October 2026 starting in April. And we look forward to seeing, or rather, we look forward to you guys seeing all of us in April. Thank you guys for joining us, and please, as always, leave us a review. Tell us if there's any cases we didn't cover that you would have wanted to hear about so we can make our plans for the future. And join us next time, whenever that is, for more Rightly Decided.